Hi, everyone. My name is Smita Ghosh, and I'm an appellate counsel at the Constitutional Accountability Center in Washington, D.C., which means I get to spend my time researching the text and history of different statutes and constitutional provisions in order to help with CAC's litigation. And one case that I've been working on is a case that the Supreme Court heard oral argument in today about a rule coming from a federal agency called OSHA, the Occupational Safety and Health Administration, that requires employers with more than 100 employees to take provisions to protect against the COVID pandemic. Specifically, OSHA required these employers to ask workers to either vaccinate themselves or to wear masks and participate in weekly testing. OSHA is an agency that was created in a 1970 act called the Occupational Safety and Health Act. And that act allows the agency to make emergency workplace safety standards if it determines that the standard is, quote, necessary to address a grave danger from exposure to substances or agents determined to be toxic or physically harmful. And I'm reading from 29 U.S. Code 655C if you want to follow along at home. And also just if you want to remember those phrases, necessary and grave danger, because they came up quite a bit in oral argument today. So a lot of organizations and some states challenged OSHA's vaccine or testing rule, and all of their challenges have been consolidated, which means that there's a lot of legal arguments going on here at once. But most of the pertinent challenges involve that statutory requirement, the idea that the emergency standards need to be necessary to protect workers against a grave danger. And another challenge to be aware of is one that CAC has a very special interest in and concern with, involving a constitutional doctrine called the non-delegation doctrine. And that's the idea that Congress cannot give a federal agency, so OSHA is a federal agency whose secretary is appointed by the president, the power to make law, because that would be delegating a uniquely legislative power to someone who is not in the legislature. So this is a doctrine to watch because it can easily be taken to extremes in a way that would really limit the government's ability to take action. You don't always want to wait for Congress to make a detailed law in a situation, say, like this one, that requires both quick action and scientific expertise that members of Congress may not always have. So a couple things about oral argument. One is just underlying the conversation today was the fact that COVID-19 is still a serious pandemic. And sometimes this was explicit. So think of Justice Kagan reminding us that nearly 1 million Americans have died from COVID-19. And she said very dryly, I don't mean to be dramatic, I'm just stating facts when she said that. I found that very striking. Another thing is the fact that the Omicron variant has risen in the last couple of weeks, maybe after the Supreme Court scheduled this argument. That variant, which is even more transmissible than previous ones, has made workplace safety regulations even more pressing. And as Justice Breyer pointed out, cases have continued to rise because of the new variant. Over 700,000 positive cases were registered in America yesterday, again, explicitly underscoring the seriousness of this pandemic. More on the implicit level, Ohio's Solicitor General, who argued on behalf of some of the challengers, himself tested positive for COVID and participated in the oral argument remotely because even the Supreme Court, which is also a workplace, has a rule that requires lawyers who participate in oral argument to take a test and wear a mask before entering the building. So another thing to think about is that several justices, including Justice Barrett and Chief Justice Roberts, really focused on the breadth of the mandate. And they spent a lot of their questioning time distinguishing between a mandate that might apply to some especially dangerous workplaces, say the dentist or an assembly line where workers are very close together, and this mandate, which applies much more broadly to all employers of more than 100 employees. Although this mandate does have exceptions for workplaces that can show that they're especially safe, as Justice Breyer pointed out in one of his questions, but that didn't seem especially convincing to many of the justices. So lawyers for the challengers to OSHA's mandate seem to concede that OSHA could regulate this issue on a more industry-specific basis, and their objection was really to the fact that this mandate spans, as one of the lawyers said, from coast to coast. Of course, as the Solicitor General of the United States pointed out, it's not so much that OSHA's action is unprecedented and especially broad. Another way to think about it is that the COVID-19 pandemic is what really lacks precedent because it's such an easily transmissible disease that can really endanger people who are not vaccinated. And remember that statutory language that allows the agency to take emergency action in cases of, quote, grave danger. Another thing that came up a lot is from both Mr. Flowers, again representing the state of Ohio, and several of the challengers to this OSHA vaccine or test mandate, and several justices also emphasized what they called the who decides question. They wanted to concede that protecting people from COVID is important, but they wondered why states can't address the problem or why Congress can't address the problem. They thought that the issue was really the fact that OSHA, a federal agency empowered to make sure that workplaces are safe, is really the one that's doing this. So what they seem to be referring to in some of those questions is the idea that states have a police power over health and safety. Although, as Justice Sotomayor pointed out in one of her questions, many states and localities have actually prevented employers from requiring masks, which kind of underscores the need for multiple different decision makers to protect the safety of workers. And more broadly, as both Sotomayor and the US Solicitor General emphasized, Congress has the power to do things that states can also do. And Congress has addressed this problem. It gave OSHA the power to take action to protect workers from grave dangers based on its power as Congress to regulate commerce. So Congress and the states kind of share power, and OSHA does too. Finally, many justices raised the issue of what is often called the major questions doctrine. And that is a theory that courts should not defer to agency interpretations of ambiguous statutes if those statutes implicate questions of major political or economic significance. So I'll note here that the challengers to OSHA's rule described a broad version of this doctrine, and one that would invalidate any agency action that addresses an issue with a broad size and scope. So Mr. Flowers, the Solicitor General of Ohio, said that this type of doctrine was really necessary to enforce the rule against Congress delegating legislative powers to agencies. Again, that non-delegation doctrine that I mentioned earlier. A few thoughts on this. Well, first, it presents a really rigid and, in fact, kind of ahistorical idea of congressional power. This is where CAC participated by filing an amicus brief in this very case, and also in many other cases that involve this increasingly popular doctrine. CAC's brief presented examples of Congress giving the executive branch broad authority over big questions in the first and second Congresses, so as early as the 1790s. And this, of course, was an era when many of the members of Congress had also participated in drafting and framing and ratifying the Constitution. So we argue that this is a particularly salient set of examples and should really give guidance on how to interpret congressional power today. Another thing to note is that this theory of delegation impacts more than OSHA's vaccine or test rule, which itself is an extremely important piece of government action. So advocates have used the non-delegation doctrine to challenge many actions of the administrative state, and their vision of delegation would really make it harder for Congress to give any federal agency the power to deal with any important problem, including global warming and economic inequality, for example, as well as public health in the workplace. So finally, think back to the question of who decides. By seeking a broad major questions doctrine, the challengers to OSHA's rule are asking judges who are unelected officials with no experience in public health to make a determination about what issues OSHA can address and what issues they can't. So, although proponents of non-delegation and major questions doctrines say that they want to restore power to elected officials, they're also giving judges the authority to determine what questions are major or significant in the first place and to invalidate agency actions in the process. And perhaps that's neither here or there, but more broadly, I'll just say that there is nothing undemocratic about Congress deciding to give agency experts who, as Justice Kagan pointed out in one of her questions, are also accountable because they're appointed by the president, who's elected by the people, authority to address certain problems. And that's exactly what happened here, involving a problem that is especially significant today. So there's so much more to talk about, and I hope I'll get the chance to do that soon. For now, I'll just say thank you all for tuning in. And if you'd like to read more, including reading the brief that we filed in this case, please visit our website at theusconstitution.org. Thanks so much.